Hi, I'm Dr. Joyce Alberts, clinical psychologist working in private practice, New Zealand. I've been posting some videos on my YouTube channel in regard to a number of trials. First one being Karen Reid, and the second one, which is currently underway in Massachusetts in the United States regarding Lindsay Clancy. But today I want to sort of circle back to both trials, actually, because this morning as I was listening to the Lindsay Clancy trial, as the prosecution was coming to the end of presenting their case, they called a forensic expert, um, Dr. Ian Wiffen. I'll just say Ian Wiffen. I don't think he has a PhD. Um, and that name was very familiar to a lot of people who've watched the Karen Reid trial, because Ian Wiffen gave evidence in both the first and second trial. So I was listening to attorney Melanie Little's coverage of day 14 of the Lindsay Clancy trial in the early hours of this morning, and heard the name Ian Wiffen, and of course that caught my attention. And just as attorney Melanie Little and others, I was very interested to hear what Ian Wiffen might have to say. And I will give you just a little bit of a spoiler alert. At the end of his testimony, even under, cross-examination, it just really wasn't clear what purpose it served to call this particular expert. But I can't show any excerpts from the live trial that was happening today, as the pull camera through Court TV, due to the legal constraints, they cannot give permission to people like myself to use that footage. You can watch it live, and there are others who are covering that in the United States. I did reach out directly to Court TV and in the United States and ask if I could have permission. And they explained, someone from their legal department got back to me and explained that actually they weren't able to do that. Part of the agreement that they have with the court in Massachusetts is that they have their television, the cameras in the court, and that feed is then released to others that have been approved, as I understand, by the court. So that is why some others are able to cover that and use that footage from Court TV. But I was just going back through and thinking about what I heard this morning, and the reason why I'm smiling and chuckling, is that in the Karen Reid trial, and there were two trials, 2024 and 2025, Ian Wiffen's testimony and his evidence changed from trial one to trial two. And so I was really curious to hear how he was going to present specific evidence around the timestamps of certain activities that would occur on the phone. So in Lindsay's case, they were looking at her iPhone and her Apple Watch. So the Apple Watch being synced to her iPhone, Apple Watch tracking steps, also tracking movements up and down stairs, and also text messages, the iPhone text messages coming in, going out, as well as telephone calls. Other information that's extracted from cell phones would be photographs, Google searches on the phone, etc. So Ian Wiffen is a digital forensics examiner. His background is that he was a police officer in the United Kingdom for about 9 years, and then he moved to Canada in Calgary, where he continued for a short period of time as a police officer before moving full time to work for a company called Celebrite. And Celebrite is the company that produces software that is used in criminal trials with prosecutors or defence will download someone's phone, be able to track where they are, GPS location, who they communicated with, and etc. I've heard in many cases in other trials too, Celebrate is considered the gold standard. And there have been other commentators who've mentioned that the number of prosecutions, successful prosecutions against a person reliant on the extraction of cell phone data. So given that background, it seems clear that especially when anyone is presenting expert evidence in court, that accuracy must be paramount. So this morning, it may, if you listen to the trial, and you may be confused to hear that Ian Wiffen hedged a little bit around accuracy. He used a phrase at about. So a text message or some activity on the phone occurring at about, and then gave a time. So say at about 10:37 a.m. That at about that time, she was going up and down flights of stairs. This is Lindsay Clancy. So this phrase at about popped into his evidence multiple times. So he was clearly saying that while it has a step time stamp, you cannot rely 100% that that is the exact time that whatever data was retrieved occurred on that phone. I just want to go back to the flights of steps as well. So steps measuring altitude, so the degree that going from one level to another level, how much, I think he said something like 10, change in 10 degrees altitude is considered a flight of steps, and the number of steps that somebody would take to travel up a flight. And so they, using the Apple Watch data or the cell phone data, they can see someone's moving up and down a flight of steps. And this was really interesting as well, because in the Karen Reid trial, so just picturing again the house at 34 Fairview, the house was a two-story house with a garage and a basement. And so effectively you could say almost like a split level. It wasn't effectively 3 stories, it was 2 stories, but there was another set of steps that would take you down into the basement area, which had been partially converted into a workout area and a storage area. And so during that trial, it was clear that on John O'Keefe's cell phone, it did show that he had his phone, at least his phone, had moved up and down flights of steps. And the defence for Karen Reid, of course, were arguing that that was evidence that John O'Keefe had in fact gone inside the house and most likely had descended into the basement area. And then maybe his phone was taken back up the stairs, because eventually his phone was found underneath John O'Keefe's body when he was taken from the front lawn of that property. So during that trial, Ian Wiffen had made a statement, and he said he did a test where he drove along the route that most likely Karen Reid would have driven her Lexus to get to the Albert residence at 34 Fairview, and that because there was some undulating terrain, and he was holding the phone in his hand, that his particular iPhone or cell phone recorded the undulations while driving in the car as going up and down flights of steps. And so Ian Wiffen, for the prosecution, was suggesting that the data on John O'Keefe's phone related to going up and down flights of steps most likely occurred when he was being driven in Karen Reid's Lexus and going up and down the undulations. So again, this morning, when he's asked questions about Lindsay Clancy's phone, because there's been some dispute about was she home in the morning, and doing some Google searches on a laptop, and evidence has been brought in to show that actually she was attending a medical appointment for their oldest child and in communication with her husband due to concerns for the oldest child's health. She'd taken the daughter to a medical appointment at that time, hence going up a flight of steps into the medical centre and descending a flight of steps as she left. And Ian Wiffen again said, well, there are a number of ways that a cell phone might record steps as going up and down a flight. And again, sort of inferring that you can't rely on that particular data. Now, I challenge anyone to do this experiment and to see if your phone actually will record steps going up and down a flight of steps if you look at the health data on your phone. Because you're driving in a car up and down hills and you're holding your phone. And I have checked my phone because I've been on a plane quite a lot like recently. And so you imagine the acceleration and taking off, and my phone doesn't record that I'm going up like 10,000 flights of steps to get to cruising altitude and then descending again as we land. So okay, admittedly, I have an Android, a Samsung, so not an iPhone, so maybe it's something particular to iPhone. So I wanted to have a look at and go through some of the evidence that Ian Wiffen gave during the Karen Reid trial. So remember, in the Lindsay Clancy trial, he has again alerted to that you cannot trust the timestamps as being 100% accurate, which is a complete shift from any evidence that's been given in a trial pre the Karen Reid trial, and particularly the second trial. And this is not just my opinion, this has been voiced by many of the commentators and attorneys in the United States who have been involved in criminal trials where data from Celebrite, using Celebrite software, has been used and largely to convince a jury that someone is guilty of a crime based on text messages, phone calls, or GPS location data. So let's have a look. I want to just give you an example of what this might look like. I'm just going to expand my screen here. Doesn't seem to want to let me do that. Oh yes, here it is. So let me share my screen and I'll just show you.
That's the third one. So because it's an incoming.
Mr. Leslie, we need to enlarge.
All right. So this is from the trial channel, and I do have consent from the trial channel to use these clips and to share this data. So this is Robert Ilisi, who is cross-examining. Actually, this is this. Let me just. I'm going to just double check here whether I've got the right one or not. I think that's the second trial. I think I need to go back to the first trial. Yes, here he is. Oh, actually, there's a picture of or still of Ian Wiffen in the Lindsay Clancy trial. He's now actually got quite a full beard now. So this looks more like the 5 o'clock shadow plus, but now he seems to have rather a full beard covering covering his face, so he looks a little bit different. Here he looks quite young. No shame for looking young, as I said that before. But let's have a look. So in the first trial of Karen Reid, he's been asked questions especially about a Google search or a web-based search that was conducted by Jennifer McCabe at 2:27 a.m. You can see I've got the transcripts here along the side. And he's been asked about this because it seemed a bit strange that anyone would be sending a text message at 2:27 a.m. on the day that tragically John O'Keefe died. So I'm just going to click to that and just play that. So you can see on the screen now, you can see the internet history. This is from Jen McCabe's phone. You can see that there's information. Here she searches apparently for, so this is just before 1 a.m., so 12:42 a.m., and she's searching a hockey group because one of her daughters had been invited to join this particular team. So you can see he's going through, looking at the information there. So let's just push play.
Two records which occurred at 2:27 and 42 seconds local time. So 2 seconds after the Google search had allegedly been made. And then the second record is 5 seconds after that at 2:27, 47 seconds. Both those URLs relate to a website, pocketmocksports.com.
If you could explain to the jury, what is a contiguous identifier?
So again, every SQLite database will assign a unique contiguous identifying number. So again, the very first record created will be given a record ID of 1, second record will be 2, and so on and so forth. Those numbers are never reused. So if I was to delete record 3, that record number will never be reused, and I can see that there's a gap and deleted data in that database.
Okay, stop that there. So you just heard Ian Wiffen explain that if a particular record you delete or attempt to delete your search history, the unique number that is given to that particular search will not be used for a subsequent search. And this is in 2024. So here he's saying these timestamps, the information from Celebrite showing what's occurring on the cell phone is accurate, and things will not be doubled up, so that you will not see a unique number that would be used again. All right, so now let's have a look, see if we can see where there has been a deleted record. And I'll explain why that's important. So on Jen McCabe's phone, an internet search was found at 2:27 a.m. on the 29th of January 2022, where Jen McCabe had Googled, well, what she meant to Google was how long to die in the cold. And infamously, she Googled how long to die in the cold. So that was at 2:27 a.m. And it's estimated that between 12:30 a.m. and that particular time, 2:27, within that time frame, something tragic happened to John O'Keefe, and his body was found in the early hours of the morning on the front lawn of Boston police officer Brian Albert. Jen McCabe having attended the, if you like, to function sort of get together at the Albert's house. And it's curious, why would you be texting or searching for something at 2:27 a.m.? These people had been out drinking on the 28th of January and continued drinking at Brian Albert's house. And here she is at 2:27 and she's apparently busy on her phone. Apparently she was back home. That's what she claims, but she definitely has made the search. So let's just go back to sharing the screen, and I'll play this portion before I move to trial number 2. Here we go. This should be on the screen here. So let's play.
Question, what are some of the reasons why this?
Sorry, is it deleted? Oh, the record itself has been deleted. As I said, the reason why it's deleted, through my testing, I've only found 2 ways that kind of record can be deleted by the user. And I don't believe either of those ways was actually utilized on this device.
What are those ways?
The user has the option to selectively delete history items. So you can delete either one at a time, or the entire day's content, or the last 2 days' content. Or you can delete all content altogether. If all content had been deleted, we wouldn't have found any information on this phone at all related to web history, so I was able to discount that one quite quickly.
Yes.
So here you hear Mr. Wiffen explaining the way that a internet search could be deleted from a phone. And this is important because after after John O'Keefe had passed away, and not immediately was Jen McCabe interviewed by the police. In fact, she was spoken to by the police, but she never made a formal witness statement. She was asked to provide information from her phone. She asked the police if she could delete text messages between herself and her daughters, as she considered these to be private. And the police allowed her to do that. So apparently, the only thing she deleted were text messages between herself and her daughters. But you hear there that Ian Wiffen is now referring to the deletion of an internet search, because subsequent examination of Jen McCabe's phone showed that the 2:27 a.m. internet search by House Long to Die in the Cold, was the only record that was found to be deleted from her phone related to an internet search. At about 6:30 a.m. the same day, she has attempted to make 2 further Google searches. She attempted to enter in exactly what she had entered in at 2:27 a.m., spelt it wrong, so then did a second search to do the correct spelling. Now, my understanding is her husband, Matt, works in IT, or is contracts in IT for the United States military or government. I've seen that information presented in certain places. And it's been suggested, and I myself question, whether the 2 searches at 6:30 a.m. on the 29th of January 2022 were an attempt to overwrite the 2:27 a.m. Search. And Ian Wiffen's cross-examined on this, and he has to concede that the only internet search that was deleted was from Jen McCabe's phone was the 2:27 a.m. However, he argues under direct examination that what happened was when Jen McCabe opened her phone at 6:30 a.m. to do the two attempted searches, that her phone had opened a tab after she had been searching that hockey team and finding out information about that hockey team on their website, and that a tab was still left open on her internet search browser on her phone, so that when she opened it at 6:30 a.m., it incorrectly showed the 2:27 a.m. But that doesn't make sense, because then why would it be deleted? Because that was the only record that was deleted, not the 6:30 a.m. So it doesn't show it as an overwrite. And remember, I just showed you a clip where Ian Wiffen says, well, once you do that search and it has a unique identifier, even if you delete it, that unique identifier will not be used again. So now we have 3 different identifiers. Okay, so now I want to go back to trial number 2, because this is where it gets interesting. Okay, let me just bring up the transcript again and make sure I get to the right place. So we have evidence that is given in 2024, where he's stating about the accuracy, these unique identifying numbers will not be used again. He's stating confidently about location data on the phone. And now I want to just scroll through. It's about 1 hour 42. And this is, you're going to hear Bob Alissi, start to give, he's giving cross-examination. Right, let me share the screen and we'll go to that. Press play. So here you can see some information that's on the screen.
Watch this.
Okay, Your Honor. Mr. Wolf, can you enlarge that pursuant to the judge's order? That was in question,
Go back a
Google
bit.
search, correct?
Correct.
And you rendered in that report, you rendered various conclusions about that Google search, correct?
Correct.
And you rendered various conclusions about.
Oh, go back a little bit, Phil. Here we go.
A report for the iPhone belonging to Jen McCabe, dated December 2024.
I do, yes.
And in that report, you discussed your views of a Google search of how long
So
to
remember,
die.
this is trial 2, so this is now 2025.
And in that report, you rendered various conclusions about that Google search, correct?
Correct.
And you rendered various conclusions about what is called a timestamp.
Correct.
And the timestamp that was in question was 2:27:40 a.m. on January 29th on Jen McCabe's phone, correct?
Correct.
And the question that you were looking at is that timestamp that appeared in the data, that timestamp of 2:27:40 a.m., whether that belongs to the Google search, how long to die in the cold, correct?
How long to die in the cold.
And you testified yesterday with regard to that very issue, correct?
Correct.
Now, in your report of December 2024, you discussed the hash value of that cell phone, correct?
I believe so, yes.
Yesterday, in your direct testimony, you didn't mention anything about the hash value
You hear that? So 2024 data or analysis using hashtags, timestamps was critical. It was presented as being accurate and reliable. And something's changed because now in 2025, he doesn't even mention it in his direct testimony, and he's being cross-examined on this. So let's jump forward a little bit.
PDF containing the extraction hash value that it was unsigned. That was not an issue in your report.
The hash value matches, but because I didn't do the extraction, I'm unable to actually validate that was an original hash and hadn't been modified.
Exactly. So you didn't do the extraction, but you couldn't validate the hash value, could you?
No.
So you couldn't determine whether or not any of the data on that cell phone of Jen McCabe had been tampered with, correct?
Right. So under cross-examination, Ian Wiffen now has to acknowledge that as he did not extract the data from Jen McCabe's phone, he cannot confidently then say that timestamp is correct and accurate, that somebody might have tampered with it. So he's changing his testimony from the first trial in 2024. Let's have a look. So let's just jump forward again.
You understand there is a dispute as to whether that search was performed at 2:27:40 a.m. as the timestamp states, or whether that was performed later in the morning, say around 6:23 a.m., correct?
Correct.
You understand there's a dispute?
Yes.
Right, so he's aware there is a dispute. So remember, Ian Wiffen is a forensic expert witness for the prosecution, and this particular Google search or internet search is critical. If Jen McCabe makes that search at 2:27 a.m. as shown by her cell phone, then it would seem to point towards Jennifer McCabe being complicit in some way in what happened to John O'Keefe. Why else would she be searching that? And the disputed time being that it occurred at 6:23. I'm just scrolling through the data here. All right, so I am going to share this again because this is where it gets quite critical. You're going to hear that what's happened, what Celebrite has done to essentially address the issue of the time. Okay, so I'm going to jump through to this. This is about 1 hour 50. I'll share screen it again. Like I'm a bit on screen, but I'm just sharing over here. And listen to what happens.
The situation with the forensic tools was Celebrite Forensics Insights did not show the 2:27:40 a.m. timestamp, but another version of Physical Analyzer did show it, correct?
Correct.
In that second program, that second tool, Physical Analyzer, not only showed it at 2:27:40 a.m., but it showed it as a deleted state, correct?
It's a deleted record, yes.
A deleted record.
Yes.
Did you mention that yesterday in your direct testimony?
I don't believe so.
You don't believe so?
No, we changed it since then.
Exactly. You changed it since then.
There you go. Is that a mic drop moment? So the company Celebrite, referred to as the gold standard company to produce software for criminal trials, used and referred to in criminal trials, they change the data or their software so that it no longer shows that 2:27 a.m. timestamp. They're now saying that these timestamps are not accurate, that they cannot be relied on, and because they cause confusion, that the more recent versions of their software no longer will provide information around timestamps. And yet another company that produces software to enable law enforcement or others, whoever is doing the extraction, to extract data from cell phone, have continued to produce these timestamps. You also heard that Ian Wiffen again has to acknowledge that the 2:27 a.m. record is deleted, and it is the only one that's deleted. The ones at around 6:30 a.m. in the morning aren't deleted. Those two are still there, but the 2:27 a.m. shows up as a deleted record. So even though it's been deleted, they can see at 2:27 a.m. entered into the search, the internet search, the Google search were the words house long to die in the cold, and then attempts were made at around 6:23 a.m. To repeat that search to, and what I'm going to say in my opinion was to overwrite the 2:27 a.m. So how does Celebrate address this issue? You heard Robert Alessi say, look, this is in dispute, this is critical to this case. Prosecution saying the 2:27 a.m. search didn't happen based on the information you've been providing to the prosecution, and the jury heard you yesterday give this particular evidence. You never mentioned the timestamps, and now you're telling us that your company has addressed that issue by now removing the timestamps. So what do you think of that? Now, if you thought that was crazy, I'm going to pause for a minute, and then I'm going to introduce you to Shannon